Hello, everyone. Welcome to today's program, Responsible AI Use Within Law Firms, Policies, Training, and Oversight for 2026. I'm Ala Policastro, Director of Education and Professional Development at Beverly Hills Bar Association, and today I'm delighted to introduce our speaker, Oliver Roberts. Oliver is co-director of the WashU Law AI Collaborative and an adjunct professor of law, where he teaches at the intersection of artificial intelligence, policy, and law. He is also CEO and founder of Wickard, co-head of the AI practice group at Holtzman Vogel, and editor-in-chief of the AI and the Law publication at the National Law Review. Oliver designed and taught the nation's first required law school AI course and has developed AI education programs both domestically and internationally. His commentary on AI policy and technology appears regularly in Bloomberg Law, National Law Review, The Hill, and Law.com. As a practicing attorney, he handles high-impact litigation, including appellate work before the Third Circuit Court of Appeals. We're so excited to hear what he has to share with us today. Please feel free to put your questions to him in the Q&A box, and I'm going to turn it over to him.
Thank you so much, and thank you to the Beverly Hills Bar Association for having me. Really appreciate being back here. This is now my third time at the Beverly Hills Bar Association, second time on AI, and also did a tax presentation back like 3 years ago because I had one tax case before the Third Circuit. So we presented about that. But today's focus is all about responsible AI use within law firms. This is, of course, a very hot topic, trying to balance the two competing interests of rolling out AI and being an innovative law firm, but also being well aware of your professional and ethical obligations. And those are not mutually exclusive. It's very important to have both. So I already had my biography read. I'll just note that I'm managing attorney at the Roberts legal firm. Actually left and started my own firm a couple months ago, focused on litigation and also advising tech companies and organizations on AI implementation. So I probably don't need to go in depth and tell you how important AI is as a topic today. You really can't go to a webinar, conference, anywhere without someone bringing up AI in the legal profession. It is, of course, touching legal research. It is touching drafting, contract review, summarizing depositions. It's being used widely in e-discovery. So it is all over the place, and it's also very much leveraged in marketing now, where law firms are adopting AI tools. Some law firms, candidly, are adopting AI tools for the sake of adopting AI tools. And then internally, they'll tell everyone in the firm, we've rolled out AI tools, and then very few people actually use them. And I can tell you that's a reality because some law firms will actually hire my company, Wickard, to come in and help show them how to actually use those tools. So we're very much in a weird, I'll call it a weird environment where it's not like the past where law firms would buy technology and tools because they see there's efficiency gains. We're now in a position where some law firms are just buying these tools so that they could say, we have the same tools that our competitors have. And so they can make the announcement and say, we're an AI first, AI native, technology first, whatever marketing term you want to throw out there. Firms like to be able to say that because it shows the market they're innovative. It's going to help them get clients potentially in proposals. But the reality is, the adoption rates, I don't think actually, when I say adoption rates, I mean actual usage of AI tools daily and weekly by lawyers. I don't think it actually matches up to what all the marketing hype says. So we'll dive into that a little bit more, but that does not discount the fact that even at firms that give their lawyers access to AI could potentially be even more problematic. If a firm just buys AI for the sake of buying AI, tells all their lawyers, here's licenses, but then leaves them without direction. Doesn't tell lawyers what can you use it for, what should you not use it for? You don't give them proper training and guidance. That is a very problematic scenario where you might be at more risk when your lawyers don't have clear direction on how to use these tools because your firm just adopted it for the sake of adopting AI. I'm going to give you some stats here just to round it out, rather than me providing just anecdotal evidence of AI adoption or lack thereof. This is a recent study that came out from Thomson Reuters. I always say this when you look at a legal tech company releasing a survey about AI adoption, I think you should look at it pretty skeptically. So I'm going to provide these numbers with the strong caveat that, again, this is a legal tech company. Legal tech companies have a very strong financial incentive to tell you, a practicing lawyer, how widely adopted AI is, because then it creates a FOMO effect. If you see a stat that says 97% of lawyers now use AI, and you're an attorney and you're not using AI, you're going to be like, oh crap, I got to start using AI. I am falling behind. And that 97% of AI adoption sounds ridiculous, but in September of last year, there was actually a group of researchers that released a published study that said 97% of lawyers are using AI now. And it's, quote, universal throughout the legal profession. But then you actually look into their study and they surveyed like 82 people and they found those 82 people within the researcher's own like LinkedIn network, which is just absolutely ridiculous. There's over 1 million lawyers in the country. They surveyed 82. The people they chose heavily biased and skewed toward their connections who are obviously interested in AI because they're in the same network, and then use that to extrapolate and say 97% of lawyers use AI. Totally ridiculous. So that is why I'm heavily skeptical of all the surveys I say, all the adoption rates. Another one is Clio. They released a report in 2024 saying that 79% of lawyers are using AI. They ran the study again this year, released in fall this past year, 2025. Same exact number. So according to them, there's been no change. But I think this really goes to how I don't think these surveys are reliable. Look at the definitions of AI. The reality is there's two issues there. One, how are they defining AI? Who are they surveying? Are they just sending this survey out to their customers who are already subscribed to their AI platform? Obviously, they're going to say they're using AI in higher numbers if they're only reaching out to their customer base. And the other concern is it also presupposes that all these companies are using the same definition of AI, presupposes that a lawyer even knows whether they're using AI or not. I would venture to guess that if you went and talked to a bunch of lawyers and said, "Are you using AI?" Some will say, "Yeah, of course I am. I'm using Lexis Protege or Westlaw as co-counsel." But then another lawyer might say to you, "No, I'm not using any AI." But then you ask them, "What's your practice area?" And they'll say litigation. Then you could ask them, "Are you using Westlaw, like traditional legal research?" And they'll say, "Yeah, of course." Well, that's powered by AI as well. When you make a search inquiry on a legal research platform, the answers, the responses you get, all those cases that are produced, it's not just giving you random cases. It's not just giving you the most recent case in the database. It is using algorithms, which is a form of artificial intelligence, to surface what it thinks is the most relevant cases to your search inquiry. So yes, AI has been around for a very long time. So that also shows one of the weaknesses of trying to survey lawyers about AI use and adoption. Even the lawyers may not actually know whether they're using AI or not. So it really undermines the accuracy of these studies. With that very heavy caveat, here are some stats if you want to put some numbers around it. But again, look into the survey more yourself. I would take it with a grain of salt. According to this report from this year, there's been a doubling in generative AI use among professionals. And this is not just legal professionals, this is professionals more broadly. Over 80% of current generative AI users use it weekly. Over 40% say that they've been told explicitly to use AI or not use AI on client work, depending on the client, which that really reflects the fact that clients are making more informed decisions on AI, whether explicitly saying, yes, we need to use it for efficiency gains or no, do not use it. I can tell you anecdotally, talking to chief innovation officers, talking to leaders at law firms, a phenomenon happening right now is a client goes to you, a lawyer, and says, I want you to use AI so you could help cut my billable costs. But then the reality is, I don't think we're really seeing huge returns on that, where a lawyer may be using AI for legal research or legal drafting, but it's not necessarily being reflected in less billable hours. A lot of that may be due to the fact that you need to double check your work. You still need to verify. Like if I'm doing legal research, I might use co-counsel from Thomson Reuters. I'll be able to put in a search inquiry using the agentic search, let it run on autopilot while I do other things. But then when I get the result, I know right now I can't trust those citations 100%. I cannot trust the legal propositions or quotes appended to those citations. Therefore, I'm going to have to spend time still going through all that case law, verifying the legal propositions, reading the case myself. So it does save a little bit of time just pointing you in the right direction and perhaps surfacing the most relevant cases, but you're still spending a lot of time re-reviewing those citations. On the drafting side, may cut down on costs, especially contract review. You don't have to start from scratch. You could easily pinpoint provisions that may be problematic. So you may see more time saving there. I think one of the few areas that's actually seeing clear cut cost savings is in e-discovery. Of course, you have tens of thousands of documents in e-discovery. Imagine you're on a huge case. You're able to now cut that review time significantly. And as long as you have a defensible basis by which you're carrying out that methodology, you could see savings there that you could pass on to the client. And then finally, very interesting stat here. 50% of publicly available tools such as ChatGPT are still the most commonly used. Across all the surveys, again, take them with a grain of salt, but all the surveys I have seen from law.com, from the ABA Legal Technology Survey, Thomson Reuters here, they all say general purpose models are the leading legal AI tools used among professionals. I throw in Microsoft Copilot in there as well. A lot of companies have access to it just by virtue of having access to the Microsoft suite. So even for lawyers, it is the general purpose models that are most widely used. That is very important to understand, especially as we now have seen many cases. For example, Southern District of New York, one out in Colorado, one in the Eastern District of Michigan, where judges are now making rulings on whether using a general purpose model like Claude, that was in the instance of Southern District of New York, whether using Claude for legal communications could waive attorney-client privilege, or whether it's actually can you claim work product doctrine to protect your communications with a general purpose chatbot. When I say general purpose, I'm talking about ChatGPT, Claude, and Gemini. They're general purpose models, meaning they're just open to the public. They're not tailored specifically for the practice of law. That is in direct contrast with Lexis, Westlaw, Harvey, Lagora, all these tools that are marketed to lawyers specifically that have added UI UX, that have added database access for the specific practice of law. So general purpose models are still winning in terms of adoption rates based on all the surveys I've seen, and also I'll say based on anecdotal evidence in my communications with firms. I'm also a writer at the National Law Review. We recently did some interviews with some smaller practitioners, some firms between one lawyer all the way up to 15 lawyers, and they are also adopting general purpose models. The rationale for it is not the performance, but it's just the cost. Some cost comparisons. I've seen recent reports that Harvey charges a couple $1,000s per seat per month, whereas you could go out there and get a ChatGPT paid subscription, $20 a month. You could roll out an enterprise license of Google Gemini for $50 per seat per lawyer. So it's a lot cheaper than buying access to the legal tech specific tools. That, of course, comes with trade-offs. For example, Harvey has a LexisNexis tie-in where essentially you could access LexisNexis legal research cases when you do legal research. Thomson Reuters co-counsel, of course, has access to the Thomson Reuters database of cases. So rather than just getting a search result, you're actually getting a search result hyperlinked to real cases. So you could easily open it up and then find the answer. And those answers are grounded in real case law. Do they still hallucinate? Yes. And we'll get into that later on. However, it does so at a much lower rate and also surfaces the relevant case law much quicker, as opposed to you going out and trying to use ChatGPT or Claude for legal research. Good luck to you, because you never know whether the cases you're going to get are real or not. Oftentimes, it'll link to Justia or some other internet web page to show you the case, and it doesn't actually link you to a real reputable database like Lexis or Westlaw. So now you find yourself in a situation where you're using ChatGPT or Claude, you get some case results, you got to copy and paste the case citation, try to go find it independently in Westlaw or Lexis, verify it, and then even see if that information was accurate. So there are improvements on the legal tech products that do deliver better value. But again, it's an open question whether that value is better vis-a-vis the actual cost of the seat of using that product in the first instance. So shifting over to some of the professional responsibilities to consider for lawyers. Imagine this, you're considering adopting AI tools or you already have. These are some of the things that should really be top of mind when we're talking about your ethical and professional obligations. Number one, competence is a requirement that's been around pre-AI, and all of these rules have been around pre-AI. California is currently considering amendments to its rules of professional conduct. But to my knowledge, they still haven't passed yet. But essentially, they're not fundamentally changing the rules. These rules are still going to be important. They're going to stay as is, but there's increased clarification of their application to modern technology and AI. So there might be slight changes coming down the pipeline, but these core rules still stay in play and are still extremely important. Number one, competence. So I'm going to jump in a bit to going more in depth on these, but I'm going to run through them quickly here. So competent, you need to be competent using these tools. You need to fully understand the benefits and risks before you start using them in actual client work. You need to maintain confidentiality. You need to know if I'm putting my client information into AI tool XYZ, is this going to maintain confidentiality? Or is there an instance where my client information might get trained on, or it might be disclosed to other users within my firm? That could be highly problematic if there's a Chinese firewall set in place. And there's even some instances where you put in data into this chatbot and that data could go to other users at other firms who are using the same product. Very rare for that to happen with established legal tech companies, but if you're working with an early stage startup and they don't have their stuff together, could be a reality that happens. Communication with clients, this gets down to the question of, do I actually need to disclose my use of AI to my client? Do I need to get their permission before I use AI? We'll jump into those questions later on. Supervision, this is now a super hot topic. Supervision, there's always been this obligation for you as a supervisor. You don't even have to be the managing attorney. If you're just a partner at a firm and you have associates working under you, you have counsel working under you, some are associates, you are responsible for the acts that they engage in. If you're not properly supervising their use of AI and your summer associate does some research, includes a fake citation, you add that to the document that you're about to file. It's a motion to dismiss. And the court says, hey, here's an order to show cause. Why should I not sanction you for including a fake site? It is no excuse whatsoever to say, sorry, that was a summer associate. Although I'll actually caveat that because there was one case in which a lawyer did that. And the lawyer actually had the summer, it was a law school intern. The law school intern signed on to the filing. And I think this was actually California, signed on to the filing. And the judge did not sanction the lawyer because the judge said the law student also signed on. So to avoid getting the law student getting in trouble as well, the judge actually sidestepped sanctions. That lawyer, then a couple months later, filed another fake citation. So the lawyer got off in that case, but then was actually sanctioned because the lawyer did it again. But that was a little side note. The reality is, it's not going to be an excuse for you to say, some summer associate or someone under me filed that fake site. Your Honor, you filed the pleadings, you're responsible for it. Even if you do not file the pleadings and you don't sign off on them, but you are supervising that associate or you're supervising the team that filed that fake site, you could also potentially get sanctioned. That happened in a case involving everyone's favorite personal injury firm, Morgan& Morgan. This was February 2025. They retained local counsel in Wyoming. It was Morgan & Morgan actually doing all the work. The local counsel signed off on it. It was a motion in limine. They included 8 fake citations. 8 out of 9 of them were fake. And the judge ultimately sanctioned the local counsel, sanctioned the Morgan & Morgan attorney, and sanctioned the supervising partner of the partner that actually filed the fake citations. So just goes to show, if you're supervising, you're responsible. Even if you don't file the pleadings, sign off on them yourself. If you're involved in the work product and the flow and the supervisory capacities, you could be at risk of sanctions if someone on your team files fake sites. Candor to the tribunal is another hot one, and this usually comes into play after you realize you've filed fake citations. There has been trends where lawyers have gotten lower sanctions if they admit to what they did. In a lot of cases, lawyers will try to obfuscate the situation and say, Your Honor, no, I didn't use AI, or make up some excuse. And very rarely, if ever, do they get out of that. So owning up to it, being truthful to the court could actually help you in reducing sanctions. Reasonable fees. This gets to the question of, what can I charge clients? There's, of course, this paradox, this billable hour paradox, where lawyers typically make more money if they spend more time and bill more hours to a client. Now you have this new technology. I say new technology in scare quotes because really AI has been around since for decades now, but generative AI has really come onto the scene and changed a lot of the tools that we're using. So this technology, generative AI, comes onto the scene, promises all these efficiency gains. We're going to cut the amount of time. We're going to cut your contract drafting costs in half. We're going to save you all this time on legal research. And the lawyer thinks, well, doesn't that mean less billable hours? So the debate now is, if I use an AI tool for legal research or contract drafting, and it used to take me 10 hours to do this, but now I'm using Spellbook for contract review, and it takes me 5 hours. Can I charge 10 hours because that's what it would have taken me? Or can I only charge 5 hours? We'll get into that answer to that question later. Unauthorized practice concerns. This is less so, I'd say, a concern for lawyers directly. This may come up in the future. OpenAI, in a case involving NIP and life insurance, OpenAI, the makers of ChatGPT, they were actually sued for unauthorized practice of law. Essentially, what happened was there was this litigant whose case basically came to an end. Then she pulled up ChatGPT, started asking ChatGPT, like, do I have a case? And of course, ChatGPT gaslighted the person and was like, yeah, you have a great case, bring the case, file again, filed again. And then the insurance company is trying to say ChatGPT is engaging in unauthorized practice of law. Will it go anywhere? I highly doubt it. I don't think that lawsuit will go anywhere, but I do think we're going to see a future where these legal tech companies may move into the direct provision of legal services. This is a hot claim. I don't think anyone's really talking about it right now. You've, of course, heard of AI native law firms like Crosby, but they are still law firms. They have lawyers. It's lawyers delivering services that are augmented by AI powered tools. But I could imagine a future where literally tools like Legora, Harvey go direct and provide legal services to companies. I think it manifests in the form of these companies providing an AI chatbot directly to in-house counsel. And this is already happening. The only difference is they disclaim and say they're not legal services. They are not legal. They're not providing lawyer services. But it raises the question, where do you even draw the line? If you have a legal tech company right now that gives you a chatbot and gives you case research and now gives you analysis when you ask it a question like, where would we have personal jurisdiction over a defendant? And you search that, and now you have chatbots that not only surface case law, but surface analysis and give you a final decision. Is it sufficient just to put a disclaimer at the end to say, this is not, this is not legal advice? And therefore that just disclaims, and now that's not legal advice. Whereas if you don't put that disclaimer, it's considered legal advice. I do think the line is a lot more blurred than people think right now. Vendor management is another very important thing to consider as we talk about responsible AI adoption at law firms. Going out and just adopting AI for AI's sake, firms are doing it. Probably not the best strategy. You should be very much so vetting vendors, look out into the market, see what other companies, what other organizations, what law firms these vendors are actually working with. I hate to say it. I mean, I have a startup, Wickard. We're kind of a startup, kind of now. We're 2 years in, but we were building legal tech in the beginning. And I could tell you, hate to say it, but I was a former tech founder. But I mean, early stage startups, they probably don't have the best technological safeguards in place. So, will they live up to the standards and requirements that you need as a lawyer to ensure that confidential information is not going to be trained on? Can they really guarantee that there's encryption in transit and at rest? So, you should very much, I don't want to dissuade you from working with early stage startups, but you should very much pay attention to what their practices are because it could ultimately lead to issues for you as a lawyer. And for bigger firms that have the resources, usually you have an IT team help review the legal tech vendor and the product that you're being sold to and ask the right questions. Time permitting, we'll get to it at the very end, but I did put a list of questions to ask vendors and what you should know about an AI tool before you actually adopt it. That also goes hand in hand with cybersecurity and data governance. There's usually somewhere a situation where you'd bring in an IT consultant or professional. Of course, smaller firms really don't have that luxury to do that. So in those circumstances, reviewing the terms and conditions, reviewing the privacy policy, looking at what other law firms that vendor is working with is very important, but asking the right questions is extremely important, no matter what size you are. And of course, client trust. There's another big consideration. Talk to your clients, understand, are they going to have an issue if you're using AI? Are they going to want you to use AI? Are they going to want you to not use AI? So getting on the same page with their client is very important in that respect. I will say some clients just do not care. Like a lot of clients are just not in tune with all these changes. If you're representing a high profile tech company, of course, they're going to know about AI's benefits and limitations. But if you're like in personal injury, if you're in an area that's not necessarily tech forward in terms of the clientele, they might not even have an opinion on AI. But it may be important for you to disclose that or tell them we're going to use AI in your representation because you don't want to be in a situation where you face malpractice issues. And it probably wouldn't just be a malpractice claim saying, oh, you used AI, therefore I'm going to sue you for malpractice. It might be a situation where someone on your team files a fake site in court. Then the client's very unhappy. And now they file perhaps a malpractice claim against you, not just because you used AI, but because you misused it. And then as a double add-on, they'll say, and I never approved that as the client. So those are some of the things to consider. Worst case scenario, and it's very easy just to talk to the client, say, hey, in your representation, we'll typically use these AI tools. They deliver better quality, better efficiency. We're going to review all the output and still use our legal judgment, but just want to let you know. And probably best practice, I do this. I put it right in my engagement letter. It's its own section, methods of delivering legal services, and I'll talk about some of the tools we use, some of the methods, and clearly disclose the limits and benefits of these AI tools. Really doesn't hurt to add in a paragraph into your engagement letter just to cover. So as we shift to talking about more of the comprehensive framework, this last slide was just about talking about some of the professional responsibilities to start thinking about. We'll go more in depth on some of them. But when we talk about AI governance as a whole, to take a comprehensive approach at your firm, here are some of the things that you could tangibly start implementing. Number one, a policy. This is very important. I know a lot of smaller firms will have no AI policy, especially if you're a solo practitioner. You might think to yourself, why do I need an AI policy? It's literally just me and what I do. But if you have multiple people, especially if you're managing summer associates, even if you have another partner on your team, very important to have some policy in place. At the very bare minimum, it should be addressing what AI tools are we permitted to use at the firm, which ones have certain restrictions on them, and which ones are outright prohibited. And we'll go more in depth on what should actually be in the policy, but that's like the bare minimum. Because you may think, why do I need a policy? Well, if you don't have a policy, it's going to be the Wild West. People at your firm are just going to think, oh, I'm going to use whatever AI tool I want. And this is not like the old days. I'll put old days in scare quotes because I'm talking like 3 years ago. This is not like the old days where you'd have to worry about a new associate, a summer associate, showing up to the job and being like, oh, I'm going to use my own legal research tool. And I have access to it. I'm just going to use it. And I don't want to use your firm tools. Like, obviously, that's really not going to be a thing. Like, you have Westlaw, you have Lexis, they're pretty expensive. New lawyers are not just going to have their own private, personal accounts. And you're not going to have to worry about them doing their work on their personal accounts. That has totally changed now. There's free versions of basically all of this software. There's free versions of ChatGPT, free version of Claude. A lot of people will pay, even college students will pay for the upgraded $20 version, so they're not rate limited and they get better output. So it's very much a reality where your younger associates, your summer associates, they have their own personal access to these tools. And if you as a firm have not clearly dictated whether that's allowed, whether you're allowed to use those, about what are some of the restrictions, about whether you have to use firm products, and a real scenario is this. Your firm has no policy on the books. You've never told your summer associates, you never told your younger associates anything about permitted or restricted AI tools. I could venture to guess that your associates are using their own personal products for legal work on the job. I don't want to say guarantee it, it's a little too far, but I could tell you they're using it. There's one firm I work with who had no policy on the books, nothing at all. And the first step I said, let's start with a survey. There's a mid-sized law firm. Send the survey out to all of your lawyers and ask them what AI tools are you using right now for your work. Overwhelmingly, majority were using ChatGPT. There was no approved ChatGPT at the firm. There's no enterprise license. So people were literally using their own personal ChatGPT for legal work. And we have no idea. They had no idea. Was it free? Was it the paid version? And even in the paid version, automatically by default, you go into your settings, toggled on is train on law firm data. So just goes to show if you have no policy in place, that doesn't mean people are not using AI. It's called shadow AI use at work. So that is very important to understand. No policy is not a good approach. You clearly lay out what tools are permitted, what tools are restricted, what is absolutely prohibited. At the bare minimum, like almost guaranteed, you have to tell your lawyers you cannot be using your own personal AI tools for work on the job. That is highly problematic. So policy is very important. Going hand in hand with policy is training. Before you use the tools, that is ideal. That is ideal. Before you actually adopt these tools, before you roll them out to your lawyers, you should train your lawyers on the tools. What are the risks? What are the benefits? What is AI? This all goes to the duty of competence 1.1, rule 1.1, in which you actually have to understand the technology before you use it. So, how to properly use it, what are the limitations? Big misconception right now. I think we're shifting, and this is kind of is now a more general understanding. But originally, people knew about the hallucinated citation issue, but they thought it was just ChatGPT or Claude or Gemini, all the general purpose models. And then people felt a little bit safer when Thomson Reuters co-counsel and Lexis Protégé rolled out the hyperlink feature, where if you're using the AI-powered agentic search on those platforms, you get a response that looks like ChatGPT, but they promise to hyperlink the cases. And you click on them, and they open up to real cases. So people got this sense of relief, like, oh, okay, I'm not doing research on general purpose models, so I'm using legal tech specific tools. These are reputable companies, the cases are hyperlinked, that's great. But the reality is, even those hyperlink cases could be hallucinated. And now the issue is the legal propositions attached to them and the quotations. So the scenario is this: you get a real case citation, you click on it, you verify the case citation is perfect, it's real, it exists, but the legal proposition it gave you and then cited the case for might be completely fabricated. And then purportedly there's quotations from that citation. The quotes could be totally made up. So I know of at least 5 cases now which lawyers have been sanctioned. And when the order to show cause is issued, they said to the court, well, court, I used Lexis, I used Westlaw, and there's another legal research company out there. I've seen their name in a lot of these proceedings. It is the lawyer saying, I didn't know legal tech tools could hallucinate. I've used Lexis for many years. There's one guy in New York Supreme Court. He said that I was using Lexis for years. I was a Lexis rep in law school. That's what he literally wrote in his affidavit. I never knew that this new product would hallucinate because Lexis never hallucinated the traditional legal research database. So even legal research tools, even legal specific AI products hallucinate. You need to convey this in training sessions is very important. Number three, oversight. It's important. A lot of law firms, usually mid-size and larger, they have an AI committee, AI task force. They'll put usually a managing attorney on it. They'll put like a partner for usually the IP group or some group that's more tech focused, or they'll just put on someone at the firm who likes technology. At a lot of firms, there'll be a very small minority of people who are like, I love AI, I love technology, I want to get involved in it. And they usually head up the AI task force. It's also very good to put younger associates on that task force too. So you get a sense of what are younger associates thinking. I can tell you now, majority of law schools are still not properly educating students on AI. I'll give a shout out since this is California to Southwestern Law School. I know Dean Dickerson, she attended the last session here. She's very ahead on AI. I'm teaching an AI course for all their 1Ls next year, so I'm excited about that. So schools like Southwestern, they're ahead of the curve on this, but the overwhelming majority of law schools are not sufficiently training their lawyers on AI. And you may be thinking, who cares? Why do I care about law school? Well, if you're hiring these students as summer associates, as first year associates, second year associates, I could tell you they're not going to know everything about AI. And at a lot of firms, it'll be older partners who will just turn to younger associates and say, I can't figure this tool out. Can you do this or that for me? There's this assumption, this presumption that younger associates know about technology. And in a lot of cases, that's true. But these younger associates, they'll use like ChatGPT or they use Claude for like assignments in school. But I can tell you, they're not fully proficient in the limitations, the risks, and proper usage of legal tech specific tools. Law students will widely have access to Westlaw and Lexis. Typically, they'll focus on just using one or the other, but they're not well trained in Harvey, Lagora, all these other tools. So you cannot just assume your new associates are walking in the door ready to go on day one with knowledge of AI tools. Verification, super important. It should be in a policy at a law firm. No AI generated work product should ever go right to the court, should go right to a client. There needs to be human review before it goes out to anyone else. There are some firms, this is some area, this is what I do through Wickard. We advise law firms on AI policy. What is a good AI policy? I'll tell you one dilemma that we've seen at law firms is this. Law firms want to promote AI adoption. They pay for the licenses. Now they got to prove like this is good. They want people in the firm to use it. They don't want it to just go to waste. Some firms will think to themselves, we want to promote AI adoption. And there have been studies out there showing that if someone tells you their work product is AI generated, they look down upon it. They think it's lesser quality. They look down on the work and the person using it. Therefore, if you tell everyone at the firm that you're personally using AI for your work product, people might distrust you. So some firms have taken the approach of, okay, disclosure of AI internally might actually depress AI adoption rates. Therefore, our policy is going to be you do not need to tell anyone at the firm you're using AI. Just we're going to treat it the same human work product, AI generated work product. Yes, of course, if you're using the AI tools, you still need to review the final work product. But when you pass it off to a supervising attorney, a partner of counsel, you don't need to tell them you used AI. I think that's very bad policy. Why? Because I think that just seeds distrust within the firm. Because now you don't know who's using AI, who's misusing it. And the other thing is externally, there are now over 200 standing orders in courts around the country that say you have to disclose your AI use. Or you have to certify that no AI was used. You have to certify that, yes, I used AI, but I checked all my sites. In very rare cases, one in the Northern District of Illinois, Judge Sharon Coleman, she prohibits the use of AI for legal research and drafting in memorandums of law, which I think is pretty wild to ban it. But the point is this: if within your firm, you're saying you don't need to tell anyone else at the firm you're using AI, that implicates two very big issues. Number one, how are you then going to know when you go to file in court whether you're actually complying with the court standing order requiring disclosure? Because if, let's say you're the partner, you're the one filing this, you don't know if your team of five associates, no one was required to tell you if they used AI. So how are you going to know if you're accurately going to certify to the court that no AI was used or AI was used for this but not that? Another big issue, supervisory role. There's a supervisory obligation on those in managing roles at a firm to properly manage their associates. And now you're telling them, don't tell me if you used AI. I don't think that's a great way to manage who's using AI properly and who's not. It's basically just a guessing game. You're hoping that everyone in the firm is not going to misuse AI. And you may think to yourself, well, if we train everyone up and everyone follows the rules, then that's no issue at all because we're not going to have that supervisory issue. But then look at big firms, Sullivan and Cromwell, just a couple weeks ago, Southern District of New York bankruptcy court. Partner had to file a letter with the court saying, court, opposing counsel raised this issue to us. We actually have a bunch of fake citations, fake quotes in our filing. We need to correct it. One of the top law firms in the world. We don't know actually if it was the partner who did it, but the partner fell on the sword. But that's one instance. Top law firms have these issues. So if you think we could trust our entire associate class, all of our attorneys at our firm, they're never going to make a mistake, I highly doubt that. There's another instance. Another big firm is down in, I believe it was Alabama or Mississippi. A partner put a fake citation into a case, filed it. All the attorneys on the case were kicked off. That was a partner. We now have 7 instances across the country of judges, 2 federal judges, the rest were state judges. 2 of these instances happened in California. Judges have issued orders with fake citations in them. In North Carolina, a federal prosecutor practicing for over 20 years, supposedly he drafted a whole filing, accidentally deleted it, quickly had to redo it, used AI, fake quotes, fake sites. He eventually retired, although they fired him before he retired, and then he was admonished by the court back in April of this year, 2 months ago. So judges, including federal judges who've been on the bench for decades, partners at top law firms around the world, prosecutors who've been practicing for 20 plus years, they are making these mistakes. So I say this, no one is immune from making these errors. And of course, you may think to yourself, of course, you're immune if you're carrying out the proper procedures and ethics and professional responsibility rules and you're meeting those standards. Yes, but I'm saying just based on your status, based on what school you're coming from, what firm you work at, people all across the legal profession are making these lapses in judgment. So no one is immune. And that just goes to the importance of constantly reinforcing the policy, constantly doing the training, and verifying every step of the way. And I'll say when I teach law students on this topic, law students, their visceral reaction is like, this is crazy. In the US alone, we now have over 1,000 instances of attorneys and pro se litigants filing fake citations in court. And the reaction from law students is like, how are attorneys so negligent on this? Like, they know it's an issue, you're practicing for many years. Like, I would never file a fake citation. But I explain the realities of practice. The reality of practice is you have a tight deadline. Sometimes you have to prepare a motion in literally a day. You have to research a lot. You're a solo practitioner or you have just a couple attorneys. You have to own your work product and you're rushing to meet a deadline. Or you're at a bigger firm. I was previously at 2 big law firms, and I would do like small legal research tasks, and so would other associates, and eventually it would all be compiled into a bigger motion, a bigger memorandum, a bigger filing. So you have like 10 different people potentially touching the document, adding to it. And that's how errors get introduced. All it takes is one person on that team to be lazy or to be under a time crunch where they have 10 other things going on and they think, oh, I just need to look up like the motion to dismiss standard. Let me just put into co-counsel or protege, quickly get an answer, send it off to the team. They'll put it into the brief. And now everyone else who signed off on that brief, they're all responsible for the error that you put in. So I explain to law students like, yes, it seems like crazy that there's so many errors here. But then when you put in the context of the realities of legal practice, you understand how it happens so often. not excusable, but the realities of practice provide some further context for understanding why this error of filing hallucinated cases constantly occurs. Then vendor diligence, already mentioned that on the prior slide. And then continuous updating, very important. I know big law firms, talk to chief innovation officers at these firms. Some of them have now gone through 7 iterations of their internal AI usage policy. So this is not something that's just static there on the books. It's very good to get something out there immediately, especially for establishing what AI tools you can or cannot use. But I will say this is a constant ongoing process. That's why it's important to put together that oversight, number three, that AI committee. You have people who are invested, that is managing partner, of course, partners who've been at the firm for a long time who care about the reputation, risk, and future development, and then getting people who are enthusiastic, like a partner who just loves AI, early associates who are just excited about the tech, getting them on to a committee is very important. Create that institutional entity because this is not an ad hoc thing where it's just going to be let's put together one training or policy and we'll revisit it years from now. No, this is like every couple months, re-meeting, assessing what's in the market, evaluating vendors. That's also a task that AI committees have been doing internally at firms. So this gives you a sense of some of the core practical steps you could and should be taking within your firm. So where do we even get the guidance? It's a common question I get. Let's say we're starting on step one. Let's say we're starting on step one and two. You realize, all right, we gotta get a policy in place. We gotta get training in place. We gotta put it together an AI committee. Usually these all happen together. Usually you'll put the committee together first, and they'll help inform the drafting of the AI policy and inform whether you're going to do the training in-house or bring in someone from outside to do the training. But what I've seen as a common trend is law firms will typically coalesce around the ABA Formal Opinion 512 guidance. They'll look at this, incorporate it directly into their AI policy, and tell their lawyers internally, hey, here's our AI policy. Usually they range between 2 to 6 pages, but they directly incorporate the principles from the ABA Formal Opinion 512. And they say that all lawyers who sign off on this policy represent that they read Formal Opinion 512. I'm going to go through briefly some of the important elements of this ABA Formal Opinion, and I'm going to tell you why I think one aspect of the ABA opinion is actually plain wrong. Competence. Number one, I mentioned this earlier briefly, but we're going to go a little bit more in depth here. ABA Formal Opinion 512 does not introduce any new AI specific rules. Basically, what it does is it looks at all the existing rules, model rules. And for background, I think most lawyers probably know this, but the ABA, American Bar Association, biggest voluntary bar organization in the country, ABA formal opinions and also their rules are not binding directly on the states. They're only binding on lawyers if they're adopted by bar associations. So a lot of state bars will adopt forms of the ABA model rules. Otherwise, they're just model rules. Florida was out ahead pretty early. So was California on this topic. So they actually issued opinions before this ABA Formal Opinion 512. But the opinions that came out from state bars after this ABA opinion largely track the same principles. But to my knowledge, not a single state bar has adopted an AI specific rule. That is a new rule of ethics or a new professional conduct rule specific to AI. What they do is they apply existing rules to the use of AI. So they'll say competence, for example, lawyers have always had this obligation to be competent in their representation of clients. They need to quote, exercise, quote, legal knowledge, skill, thoroughness, and preparation reasonably necessary for the representation. It's in comment 1.8 to model rule 1.1 here that says this includes staying abreast of technological developments, including, quote, benefits and risks associated with the technologies. So this says nothing about AI. What the ABA did was, in its opinion of Formal Opinion 512, it said this rule applies to lawyers' use of generative AI because it's talking about technology, benefits and risks. So what the opinion says is lawyers who are going to use generative AI tools need to be competent. They need to know the risks and benefits before they actually use those AI tools. So that is essentially how this ABA opinion and other state bar guidance plays out. They look at existing rules in the books. They apply it to the context of lawyers using AI. There's not a single bar association in the country that has banned AI. They all say, yes, you could use it, but you need to use it responsibly. So competence 1.1, very important. Confidentiality is another very important one. This is ABA Model Rule 1.6. This rule says that lawyers have always had an obligation to maintain the confidentiality of all information related to client representation, unless the client provides informed consent otherwise. This is very important and is directly implicated by AI tool use by lawyers because if you're using an AI tool like ChatGPT free version or Claude free, the free version of that as well, your information is getting trained on, is going to be shared with these developers. It will be shared with third-party vendors. And therefore, your information and the confidentiality thereof is being compromised and a violation of Rule 1.6. And within state bars, the applicable rule there, which follows the same principle, says it's very important to understand confidentiality. So picking a vendor tool is not just about which tool works the best. You need to fully understand how the data is actually being processed, whether it could potentially compromise confidentiality of client information. Shifting now to communication, this is one where there's been a slight shift away from the ABA guidance here. So under communication, ABA Rule 1.4, there's always been a duty of an attorney to advise clients promptly whenever there's any information that gives rise to important decisions or questions involving the client. Most simply, you need to advise your client on important things. And according to Model Rule 1.4A2, a lawyer must, quote, reasonably consult with the client regarding the methods to achieve the client's objectives. According to according to this ABA opinion, which is interpreting Model Rule 1.4, lawyers actually must get a client's informed consent before inputting information relating to the representation into a generative AI tool. And it goes further and says, quote, merely adding general boilerplate provisions to engagement letters purporting to authorize the lawyer to use generative AI is not sufficient. So this is whenever you're putting something into a generative AI learning tool, as the ABA opinion calls it, you need to get your client's informed consent. And this is related to confidential information. So this is a pretty clear-cut rule. You need to get pre-permission. This is like you putting in client confidential information related to representation into Harvey or Legora. This is not just about general purpose models. According to the ABA opinion, you need to get your client's informed consent before you do that. And you can't even just put it in a boilerplate provision in an engagement letter. It's a pretty, I don't want to say onerous, but pretty operative obligation to now have to get on a call and explain to your lawyer, here are the benefits and risks of me using Harvey, Legora, even co-counsel, which is the generative AI feature in Thomson Reuters, and also the Protege generative AI chat functions in Lexis. This, again, this opinion was issued in 2024, July of 2024. I think it's a little outdated. I mean, you really wouldn't call up your client 4 or 5 years ago and say, hey, client, do I have permission to use Westlaw legal research? Do I have permission to use Lexis legal research? You really wouldn't do that. It's kind of just part of the practice to be using the most widely accepted legal research tools. But according to the ABA guidance, if you're putting client confidential information into a generative AI tool, you need to get informed consent from your client. I mentioned there's a bit of a shift away from this. The Texas bar, state bar opinion, as well as California's, is a little bit more lenient, where it says you should consider getting informed consent. It doesn't say you have to. So I do think we're shifting away from this requirement. I do think this is also kind of fact specific, depending on your relationship with your client. So with fees here is 1.5. I asked that question at the top of the hour. I asked, used to take you 10 hours to review a contract. Now it takes you 5 because you're using Spellbook, an AI review tool. Can I charge my client 10 hours or can I charge them only 5 hours? The answer is 10 hours. The answer is 5 hours. You cannot charge them for work you did not do. Under ABA Model Rule 1.5, you need to charge reasonable fees. It's always been the rule. So the ABA formal opinion evaluated this exact scenario that I just laid out to you. If AI is delivering you more efficiency gains, cutting into the amount of hours you're spending on your client's work, you cannot charge your client for the time it would have taken you. You can only charge for the actual time you spent on the job, even if AI cut into that time. Another question. I used AI to review contracts, took me 5 hours, but now I need to spend 2 hours reviewing AI's results for accuracy, for final review. Can I charge for those 2 hours? Yes, you can. So you can charge for 7 hours in that circumstance. That is permissible because you're still doing work on the job, you're reviewing the AI output. There's also still efficiency gains to the client. There's more gray areas to this, and the ABA opinion recognizes this. Some of these include one, let's say I'm learning how to use Spellbook, the contract drafting tool. I spent 2 hours learning how to use the tool before I used it for 5 hours. So this all would have taken me 10 hours manually. Now it's 5 hours on the job, 2 hours prep learning how to use the tool. Can I charge for 5 hours or 7 hours? You only charge for five. The ABA opinion says you cannot charge for the time you spent learning how to use the tool. To add another scenario, what if the client said to you, you need to use Spellbook? You are not going to use it otherwise. They say to you, I need you to use Spellbook. Now it takes you 2 hours to learn how to use the tool, 5 hours to do the contract. Can you charge 5 hours or 7 hours? The ABA opinion alludes to you being allowed to charge 7 hours. If the client specifically asks you that, and you make it clear to the client that you're going to be spending extra time learning about the tool, you put that in the fee arrangement up front, it's in the engagement letter, in the fee arrangement, then that's a circumstance in which that would be a more permissible practice. I'll add in other potential scenarios, and Virginia came out with its own ethics opinion on this as well, saying that you could basically incorporate into your billable hour rate. If you know that AI is driving more efficiencies, driving down your traditional business model, then you could increase your hourly rate to make up for those potential increases in quality and efficiency. But with that said, when you do that, you have to make it clear cut to your client, disclose that up front that you're increasing your billable rates. So there are interesting, more gray areas, but the ABA Formal Opinion 512 makes it very clear you can't just charge for the time you saved. All the efficiency gains accrue to your client. I'll note something else here. There's an interesting line from the ABA Formal Opinion 512. Quote, as generative AI tools continue to develop and become more widely available, it is conceivable that lawyers will eventually have to use them to competently complete certain tasks for clients. Pretty strong statement. So this is from summer 2024, like 2 years ago. Imagine 2 years ago, someone saying to you, if you don't use AI, you are not competently serving your client and you could be a risk for misconduct. Pretty strong statement. I do think this is where we're going. We are not there yet. I just don't think the tools are good enough. I don't think they've been around for long enough for people to be required to fully understand the full panoply of tools and their limitations and benefits and risks and all that. But I do think we're going to see this future. There's a judge from the Southern District of New York. He also made a similar statement back in February of this year. He was asked about whether it is misconduct or malpractice for a lawyer to be using AI tools given how often they commit errors. The judge replied saying no, and he thinks there may be a time soon where it's unethical to not use AI tools. And the example he gave was in the context of a fee dispute. And this is probably how I think it would arise too. You're not going to have a client go to you and be like, hey, lawyer, you didn't use AI. I'm going to sue you for malpractice for not using AI. I think it'll come up in the context of a fee dispute. Imagine client hires you, they don't pay you, there's a fee dispute. The client then says, going through all your billable hours here, you spent 20 hours reviewing this contract. I know there's tools out there that are commonplace in the legal profession. This should have taken you only 10 hours. Therefore, I'm not paying. And in fact, I think it's misconduct that you're charging me for 20 hours when you should have been using AI to cut my billables in half. So it's within that context of a fee dispute where we probably will see the first case involving whether it is incompetent or misconduct to not use AI tools. I do not think we're there yet where not using AI tools constitutes a breach of ethics or professional responsibility. But interesting to see that the ABA is already portending a conceivable future in which that happens. So I'm going to close out on this. Only a couple more minutes, and I might address some questions. There's a lot more content to address. 1 hour, definitely not enough to go comprehensively through the responsible AI implementation at a law firm. So I'm happy to answer questions via email after, and I'll possibly, time permitting, address some here. But I want to address a question that comes up pretty frequently. The ABA opinion recognizes, yes, you could use generative AI, but we already know these tools hallucinate a lot. So, like, at what level can we even rely on these AI tools? Like, can we trust but verify? That is a phrase I've heard thrown around so much. Trust but verify. There was even a CLE given by the New York City Bar. I think it was the New York City State Bar or City Bar. I saw it. The title of the CLE was Trust but Verify. What you need to know about AI. That's crazy. Absolutely crazy. These are tools that hallucinate, and these are old stats, 2024. I put a caveat in the slide, and you have all the materials. You'll see this if you go through later slides. I put a caveat here. A study from 2024 says that Lexus and Westlaw hallucinate between 17 to 34% of the time. Um, Again, those stats are 2 years old. I would not trust them whatsoever right now. We don't know what the updated numbers are. These are private companies. It's up to them to release it. Of course, there's this study was done by Stanford. It would be cool if they did another study to update it. But again, those are outdated numbers. I assume they're much lower. But the point is, I shared them in my slide because to prove the point, legal tech tools hallucinate too. So there's not a single AI tool out there right now that a lawyer could use where they 100% know the output is accurate. So it is absolutely wild advice, in my opinion, to be telling lawyers, trust the outputs. And of course, there's the caveat, trust but verify. But how can you start from a posture of trust when you know these tools hallucinate? And lawyers have been sanctioned thousands of times. Judges have included fake sites. That is a terrible advice, in my opinion, to say trust but verify. And I included this in the pre-materials. The Mississippi State Bar issued an official ethics opinion, and their official guidance on AI is, quote, trust but verify. So even like leading institutions are out there telling lawyers to trust AI tools that we know are not accurate and hallucinate, potentially, say the numbers are between 5 to even as bad as like 35% of the time. So that is not good advice. The question then is, how much trust can you put in them? How much review is required? And this leads to the then practical question. If we need to review everything that comes out of an AI tool, is it really delivering efficiency? Or are we just going to save time on the front end to lose time on the back end? Well, the ABA opinion gives some guidance. According to the ABA, for using generative AI tools, quote, the appropriate amount of independent verification or review required to satisfy Rule 1.1, that's the rule of competence, will necessarily depend on the generative AI tool and the specific task that it performs as part of the lawyer's representation of a client. That basically tells you nothing. And that is one of my critiques of basically all the AI ethics guidance out there. They give you these broad principles and no practical implementation process. So if you ask someone, how much review do you need to know to do? And let's say someone asks me that, and I say to them, well, it depends on the tool, it depends on the task, depends on what you're doing. Is that a helpful answer? Certainly not. They give one example. For example, if a lawyer, and this is right from the ABA opinion, if a lawyer relies on a generative AI tool to review and summarize numerous lengthy contracts, the lawyer would not necessarily have to manually review the entire set of documents to verify the results if the lawyer had previously tested the accuracy of the tool on a smaller subset of documents by manually reviewing those documents, comparing them to the summaries produced by the tool, and finding the summaries accurate. I think this is bad guidance again. Based on that example, we now have a subjective standard where essentially you're a lawyer, you use a tool, and based on my prior experience using a tool, I think it's great. Therefore, I don't have to rely on it. I don't have to do manual review anymore. I tested it a bunch of times. It's never proven to be wrong for me personally. Now I'm just going to go trust this tool. Take this example, and of course, this is the contract context, but imagine extrapolating this to any other area in the practice of law. Let's say I just did legal research on co-counsel on Westlaw, and I'm writing a motion. I have 100 citations. I use generative AI. I manually check the first 25 citations. They're all good to me. Based on the same logic from this small sample set of contracts, I did a small sample set, 25% of my 100 citations. Based on this logic, I could then say, up the other 75, Must be good to me. I don't need to manually review it. Let me go file in court. Heck no. You can't do that. And the fact that this sets up a subjective standard is also pretty crazy because you could be using a generative AI tool that is totally out there. No one in the industry is using it. But if your personal experience using it has proven to be good, then you have, for lack of a better word, plausible deniability to say, oh, I followed the guidance. I followed what it told me I could do. So I do not think this is good guidance at all. This also, there's so many other issues with this logic. Previous experience, these tools literally change week to week, month to month. If you're using ChatGPT, there's been like 6 model upgrades in the past 6 months. So this doesn't account for the fact that if you use a generative AI tool today and it's really good, a month from now, you can't rely on that same baseline. These models are improving significantly. Sometimes they change and certain tasks actually deprecate in their performance. So just because the models generally get better, maybe you're using it for a one-off task and now that process is deprecated. So I do think this guidance is not very good. I think it's misleading, and I would not necessarily recommend it. And to the point I made earlier about the Bar Association in Mississippi, definitely wouldn't follow that. Verify, trust but verify. No way. Anytime any product is going to a client, going to the court, going to a managing partner who you know is probably going to rely on that information, you need to manually verify all of it. I think that's super important. In this case with the contracts, potentially there may be an argument that if those summaries are just being used for quick review to set up then further review, where like your team is going to dive into the full contract. So eventually they will see all the information and the summaries are just to get a high level overview. That could be more acceptable for not doing a more in-depth review on just the summary, because that summary is just going to inform further lawyer judgment without it going direct to counseling a client or the court. That might be an internal use that's appropriate because you know there's more verification happening down the pipeline. But otherwise, I don't think this is the best advice out there. So I shared all the materials with you all. There's far more to this, but I want to hit the core principles and considerations. Again, practical takeaways here. If you're just getting started with the AI adoption route, highly suggest putting together some internal committee, get an AI policy out there on the books. That's very important. Figuring out, doing an internal accounting of what AI tools people are using in your firm and really getting a true sense of that might be an awkward conversation to have because someone's not going to raise their hand and be like, yeah, I've been improperly using AI this whole time. Just want to let you know. No, it's it might have to be an awkward conversation, but you need to know how your attorneys are using or misusing AI right now to form better practices. And that goes hand in hand with also the training. So those are the 3 practical steps for you all I take away from this. It's getting that team in place. If you're a smaller firm, might just be you, then getting the policy in place and coupling that with training to truly be using these tools effectively, but also avoiding potential ethical missteps, which could then turn into reputational hits. So I'm going to jump to the end here, but perhaps we'll do another session on this in the future. If you want to reach out to me, my email's here. Always happy to talk more about AI policy, training, adoption, and any other things that come to mind.
All right, this concludes today's presentation. Thank you so much, Oliver, for your time in educating our members, and thank you so much to our audience for joining us today. Have a great day, everybody.